Good afternoon, everyone, and welcome to Navigating the Deal Process, Key Considerations to Successful GovCon Transactions. I'd like to introduce you to our panel for today. Our first speaker, Sharon Heaton, is the founder and CEO of sbLiftoff. She just recently released a book on M&A titled Liftoff, 12 Things to Know Before Selling Your Business. Sharon has advised on transactions totaling more than $12 billion in deal value, and now focuses on bringing high-quality M&A advisory to the mid-market GovCon space. Sharon received her law degree from the University of Chicago Law School, a BA from Barnard College at Columbia University, and has been associated with the law firms of Skadden Arps and Latham & Watkins. Next, we have Marlena Ewald. Marlena is a partner and serves as vice chair of Fluet's government contracts practice, as well as head of the firm's government contracts regulatory compliance section, where she specializes in corporate and government transactional matters. With a focus on government contracting, commercial contracting, and sensitive government inquiries, Marlena provides expert advice and counsel to companies and individuals. She is uniquely equipped to guide government contractors through growth, merger, sale, acquisition, and novation processes. Marlena received her law degree from Georgetown University Law Center and holds a BA from the College of William and Mary. Next, we have Brad McConnell. Brad is a partner at Fluet and serves as the chair of the firm's corporate and transactional practice. With over 25 years of corporate practice, Brad specializes in technology-focused companies and those involved in commercial and government contracting sectors. His expertise includes M&A, venture capital, company formation, debt financing, joint venture agreements, employment agreements, and more. Brad's insights on emerging technology startups, venture financing, and initial public offerings enable him to guide growing companies through transactions while establishing a strong foundation for future growth. Brad received his law degree from the George Washington University Law School and holds a BA from Princeton University. Over the next hour, we encourage you to submit questions through the Q&A options at the bottom of your screen. You can submit questions throughout the entire presentation, and the panel will take the last half of the webinar to answer your questions. So Sharon, let's get started. Why don't you kick us off by giving us insight into navigating the deal process?
Absolutely. Thank you so much for the introductions, Jennifer. And it's a pleasure to be here with Brad and Marlena. I'm going to talk a little bit about what the M&A market is like right now, and then turn it over to my colleagues for them to make opening remarks. And then we'll, of course, turn to the questions that were put in the marketing for people to come to this event. The M&A market in 2024 is actually in a pretty interesting spot. While there are a tremendous amount of buyers out there, buyers have gotten pickier as to what they're looking for, and there are fewer sellers. So if you have a company in GovCon particularly that you're looking to sell and you've got a decent amount of backlog, your margins are good, there's going to be real interest in your company. One of the things that's changed is the financing ability. 2 or 3 years ago, it was pretty easy to get banks to lend at least 3 times the EBITDA of the combined entities. Sometimes you could even get them to lend 3.5. And that's the amount of senior debt you could put on a transaction. Now, in many circumstances, banks are kind of tapping out at 2 or 2.5%, 2.5 times. That means that there's going to be more structuring involved, things like seller financing, equity rollover, or the dreaded earnout. Earnout can and should be structured very carefully in order to work, but it can work well if it's done properly. That's just something that people need to know going into the process, that the market is in fact different in 24 than it was certainly in 22, where truth is anything that you could sell was selling. Now there's a little bit of a more of a deeper look at the due diligence. The structuring is more, interest rates are higher, but that's not really what the factor is. It's really the bank's willingness to provide the financing for it. So it's a very active market. For the under $100 million market, there is no one M&A market. When you read the Wall Street Journal and it says M&A is down from previous years, they're talking about publicly traded companies. They're talking about fairly large entities. We're talking about the privately held companies, and specifically in GovCon, there's a lot of interest right now. Those are kind of my opening remarks. Brad, what would you like to open up with?
Thank you, Sharon, and thank you, Jennifer, for the lovely introduction. So, looking at this from the sort of transactional lawyer point of view, one of the things, and you touched on that, Sharon, about that the market, and certainly in the mid market and small to mid market, is pretty much as active as ever. And I mean, to some extent, it's recovering from all the sort of the overfishing that happened a couple of years ago, as some of these companies grow into a size that are the point that they're either interesting to a strategic buyer or private equity buyer, or quite frankly, that they are running out of runway in whatever program that they're in, with the SBA in terms of being a service disabled veteran-owned small business, or one of the other programs where they may be about to size out. There is a certain inevitability to M&A process for these GovCons. I mean, absent being sort of what is somewhat pejoratively, although I think it's no reason to be pejorative, like term of like a lifestyle business, where it's something that you can run a very successful business that grows to the size that you can support your family and put away a nice nest egg, and never worry about sort of outgrowing your size. But for the most of these companies, especially if they have a technology focus and they're focused on growth, at some point they're either going to have to then go into a hyper growth mode, which means they're probably buying, or they're going to be selling to somebody. So being ready for that sale, being prepared, thinking ahead, meeting the people you need to meet, lining up the advisors you need to get, preparing for due diligence, preparing for what the process is going to look like, in order to make it as non-painful as possible, because it's impossible for it to not be at least somewhat painful. And as much as you can warn people who haven't been through the process, it's like, oh no, it'll be fine. I've done this. No, it will be painful at times, for no other reason than it's just the amount of minutia that lawyers and bankers will force you to get into, drives a lot of people crazy for good reasons. But the sort of subtext of everything I think that I'll be talking about today is sort of prepare. And the more time you have to do that, the easier it'll be, and the less you will be trying to do 3 full-time jobs, running your business, trying to prepare to sell your business, and then actually doing, and actually going through the process of negotiating the deal terms, right? Because it's sort of 3 full-time jobs that can stretch, the entire management team quite thin. So the more you can do that in a non-emergency fashion, the better. So with that, I'll turn
If I can interrupt you for a second, you just gave the best argument I've heard for why you should have an M&A advisor.
and
Thank
honestly,
you very much. I appreciate that.
And honestly, that is going to be part of what I, and not just because, Sharon, that you and I have become friends, but just, I mean, but even absent, like if you want to make a second best choice and not go with someone like with Sharon and sbLiftoff, there are people say, oh, I don't need an advisor. I'm good. And quite frankly, you may be able to do that fine. And people also sell their houses without real estate agents and such. And sometimes they, occasionally that can work out well because they'll save a little bit on commissions. But often, they lose on the market reach and their staging and the negotiation power and stuff like that advisors can bring to the table. So having, whether it's your M&A advisor, your lawyers, your accountants, your whoever it might be, all involved as early as possible to sort of make, and it comes back to, and I hate to use too many little trite little aphorisms, but I will, that you only have that one chance to make that first impression, right? So the better your company looks in the M&A situation, or in a private equity investment or a VC or any of these kind of things, the better your company looks from a, when these outsiders start doing due diligence, they're looking at your books, they're looking at your corporate records, they're looking at your contracts. The cleaner things look, the better things look, the more likely, you get that warm fuzzy feeling in the buyer, which you want to have, as opposed to, well, this is all a wreck, I hope there aren't other problems, right? So that's all part and parcel of the be prepared, know what to expect, have advisors who've been through the process that can help ease that ease your way through and let you know it's like, no, you're not going crazy. This is normal. Or yeah, you don't fight over this, fight over that. Or, you can, I wouldn't hold out for that because you're never going to get it. Or yeah, someone is completely gaslighting you on this, that's absolutely a term you should go with, right? So having outsiders, whether they're paid or just people who've been through the process, the
Hey,
more
let me put some
assistance you have, the better.
statistics to that, Brad. About 92% of people who are selling their homes hire a real estate agent.
Mm-hmm.
About 100% of large companies, anybody over $200 million that's going to market, has an M&A advisor of some
Yep.
sort. It's only in the $100 million market and less that people say, well, maybe I could do it by myself. And as you said, it's a one and done.
Right.
When you build your business, guaranteed you made mistakes in year one that you fixed in year two, and year two that you fixed in year three, etc. But as you said, there's no do-overs. It's a one-time transaction, and you really need to get it right. And making sure that you've got the right lawyers, accountants, and we think M&A advisors is a key element of that. Sorry to interrupt, but I wanted to
No,
support what you were
and
saying.
it's good. And eventually I'll even let Marlena talk. But she and I have been working together for a couple of years. She's used to that. She's like, it's like, okay, fine. Well, like, listen to Brad go blah, 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 blah for a while. And then she can actually say something worthwhile. But I'm a deal lawyer. So that's what we do, right? We talk all the time. But yeah, but it is true that all of these things are expensive. And I know it comes out of the bottom line, but the truth is, the more good advice you get, and I know this sounds somewhat self-serving, but even if you never hire me or our firm, or, I mean, I've talked to people who like, yeah, so I just got an LOI, and that's when they're getting their advisors involved. And I will tell them, it's like, well, I mean, better now than not now, but it's a month, 6 months, 2 years later than you should be, right? You should be dealing with your advisors throughout the entire process, because they can help, as I say, help get you focused for this process, do the preparation you need to do, tell the story that makes the most sense. Don't step, fewer missteps, right? So with that, I'll shut up for a little while, and I'll hand it over to my esteemed colleague.
No, I think, thank you, Jennifer, for the introduction as well. And excited to be doing this with Sharon and Brad. I think we've done, partnered up before, and we always have a good discussion. I think just as opening remarks go, I echo everything you all have said. I'll just add a little bit more to color to that. I think as far as the GovCon M&A market, Sharon, I think you kind of started with this, right? It's different from other markets that you might be hearing about, right, in the news. And I think in some ways it's good. And by that I mean, we talked about how some other deals might not be as active as they were in previous years. But I think as far as the GovCons go, that market has remained pretty steady. I mean, the government is a pretty good customer for the most part. It has its pros and cons, and obviously there's a lot of compliance and some fluctuation, but typically speaking, the government, is a good payer. It's a good customer. There are different sizes. I think we're seeing less of big GovCons acquiring other GovCons, but we're seeing more of private equity deals happening. I think we'll continue to see that in this year coming up. I think we're seeing, targeted purchases. And by that, I mean government contractors identifying where they have gaps and how they might be able to acquire a smaller business to fill that gap. So I think we're still seeing some pretty good deals, and we'll continue to see some pretty good deals in the GovCon market space. And of course, every year, right, there are new regulations, new requirements. And so I think we'll continue to see issues, right, which are not bad, but need to be addressed. To Brad's point, I think before the sale process begins, to the extent you can, or if not, talk to your advisors on how we can best mitigate that and walk you through the process. So I think I won't repeat everything you all said, but I just wanted to add those bits of color.
Things that I heard both of you say, and I clearly believe as well, is don't start the process when you decide to sell. That this is something you should be thinking about pretty far in advance. It's almost not possible to be thinking about it too far in advance, but realistically, at the beginning part of your company, you're going to be very focused on just getting it up and running. Uh, Starting a company is hard. Keeping it going is even harder. Most companies only last about 5 years. So if you've been having your company and it's been profitable for 5 years, 10 years, 15 years, you've already accomplished what other people haven't. However, when people come to me and say, I'm just done, I'm on my last nerve ending, I have to sell now, will we help that person sell? Of course we will. But we know that we're probably leaving some value on the table. And if people started a year or two in advance, more is better, but at least a year or two, we can generally make things stronger and make it more attractive to the buyer. So in terms of, what should I do to prepare my company? Let's talk about that a little bit. But the what should I do follows the when should I start? And the answer is yesterday. And the only best answer after yesterday is today. So it's not something that I'll get to in 2 or 3 years from now. It's something that actually preparing for a sale of your company is often the best business strategy. Because what you need to do to prepare your company for sale is what you need to do to make your company stronger. And wouldn't you rather own your company when it's stronger than when it's not? So there should be some self-incentive to do it. Now, I understand that most business owners feel like they're drinking from the fire hydrant and they couldn't possibly take on any other perspective. But the fight drinking from the fire hydrant is you're in the business. Working on the business is where you're going to create that value. And part of that value, as Brad said, is building your team. M&A is absolutely a team sport. I think there's a lot of business owners who say, I built my company by myself. Lots of people came by and wanted to advise me on this or that, and I was able to correct it. I was able to do it by myself or with minimal help. Again, M&A is a little bit different. So, Marlena, what do you think are, from a regulatory perspective, that a GovCon company should do to prepare their company in advance before going to market?
Yeah, so I think, to the extent you can start doing a compliance check, for example, and we always want to give businesses, we give them legal advice, but we want to give them practical advice as well that they can actually take action on, and not feel like I'm drinking from a fire hose by myself and I'm never going to get all of this done. And so I think, talking to an advisor, and figuring out what makes sense for your business, right? For the size of your business, for where you are in the process. Are you trying to sell in a year? Are you trying to sell, in 6 months? And what actually needs to be done? And so identifying targeted areas that need to be worked on. I think the easiest way to do that to start is use a sample due diligence checklist. It should be targeted for government contractors. I'll say that. Don't just go pull whatever one off, because they're not going to have the same things that somebody acquiring a government contractor is going to be looking for. So it is important that that due diligence list, start with the sample one, but make sure that it is written for government contractors. Start there, see, what's doable, what have you not started to think about yet, as you grew quickly. For example, we have a lot of companies that grow very quickly and perhaps, they didn't have the experienced HR director or somebody in place, and now they do. And so what, on onboarding that experienced HR director, what are the top things they should focus on? Do they have an affirmative action plan in place now that they're over 50 employees with federal contracts? And so I think just running through that list at a high level, using it as your own internal checklist before an outsider will be using it as their checklist, and seeing what areas do we need to improve upon, or, was there a requirement I wasn't even aware of? Because like you said, I think, Sharon, there's always going to be something that you can improve upon. It's just identifying that item. So I think starting with that, and then looking at your contracts. And number two, and it's close to number one for me, look at your contracts, because buyers they care about what those say. And if you're actually in compliance with them, and you're going to be making reps and certs in the purchase agreement that you are in compliance with them. So, making sure that you know what your contracts say. Oftentimes businesses will execute, right? They're excited to get that subcontract or that prime contract. And they execute it pretty quickly, and don't go back and review some of the requirements. So I think looking at those two aspects are important early on.
If I could just add a couple things, which I mean, these are excellent points that Marlene is making. And I mean, some of the stuff we're talking about applies to any kind of business, but especially the stuff that she's talking about, it is different, right? It's not just, and getting a due diligence checklist. Often, what's interesting in these kinds of companies, I mean, I got my start in the mid to late 90s with sort of the pure VC-backed tech companies, and one of the advantages they have in the M&A process is they've already gone through that kind of outside scrutiny of someone and their lawyers going through and looking at all those contracts, all those their leases, their all their organizational documents, their board minutes, all that kind of stuff, which quite frankly, most startup companies are just like, whatever I need to do, I'm just going to do something that's as much as I have to not get in trouble, quite frankly, right? And then sometime later, sometime down the road, when there's actually some money coming in, they're usually forced to go, okay, wait, I never did proper corporate organizational documents, and I've never done a board meeting and blah, all that kind of stuff. So earlier in the process, they're going to get back on the straight and narrow on that kind of stuff. Because of the nature of a lot of these GovCons that are growing more organically, they're growing, whether it's through government funding or just they're growing because they get contracts and they hire more people and they grow like that. What often we'll find is the first time that there is that scrutiny is kind of at the end. And then all of a sudden it's like, when the buyers are looking at it, like, well, their lawyers, we have a checklist, we look for certain things, and it's like, well, you didn't do an organizational consent. There's supposed to be something you do when you form the company that authorizes the appropriate people to get a tax ID number and to open a bank account and stuff like that. And you don't have one of those. And it's like, okay, yeah, that was 7 years ago and we never got around to it. But that's the kind of thing that lawyers is like, well, you don't have that and you got to fix that, which is both. I mean, yes, that's what we do because, perhaps there's a problem, but cleaning that kind of stuff up in a non-rush basis, it's like, hey, can we just fix this stuff because someone is going to look at it? You might not care. You run your business perfectly fine without any of this stuff. And there may be other things where it's like, yeah, there's some risk here, but I don't care about that, right? I am not worried about that, but it's not necessarily what your risk tolerance is anymore. Right? It's what the buyer's risk tolerance, and the buyers, depending on who they are, they don't want risk, right? Or to the extent that there is risk, they're going to discount the value from it. And their lawyers are going to be there saying, well, I don't know, this is a red flag. You better, this could be a problem. And then they're going to say, well, okay, then, so either you are trying to mitigate at the last minute, you're doing rush things. There have been times where, someone had someone got their systems hacked like right at the end, like during the process. And then all of a sudden you're spending hundreds of thousands of dollars where you might have spent tens of thousands of dollars to mitigate because you're doing it on a rush basis, right? So the more you can fix those things up, especially because these government contractors often haven't had that outside scrutiny. And there's a whole bunch more regulations, as Marlena correctly points out, that you got to be in compliance with. It's like someone might not care what their operating agreement looked like in some, tech company, but it may matter a whole lot for this government contractor, depending what program they're in. And all these kinds of things, their accounting system is not just, well, it wasn't good enough. It's like, no, actually it didn't comply with the law, right? So there is a different level of, and the more time you have between the time you fix something and the time you're trying to sell, at least you're building some goodwill towards that. It may not be perfect. You obviously can't go back in time and fix stuff, but, every extra day you have where nothing became a problem is an extra good day, right? So,
Brad, I think you're making an incredibly important point, and I want to rephrase it a little bit, which is what we're talking about is due diligence. No buyer is going to acquire a company without doing extensive due diligence. So a lot of sellers will turn to me and say, when does due diligence occur? Is it after the LOI? And I say, absolutely not. There are really 3 periods of time for due diligence. And the first, and in some ways the most important, is self due diligence. You want to either do a review yourself or, better yet, hire advisors, have a lawyer, an accountant, an M&A advisor come in and look at your company. Do the due diligence on yourself. Every company I've ever seen has strengths, but every company has challenges as well. Let's find out what those challenges are, fix what we can, or
Mhm.
at least be prepared to explain what we can't fix. Because, hey, listen, there's going to be something in every company. It is so much better and will create value for the seller if you can have a ready story. In addition, buyers can pretty much ask for whatever information they want. And if they ask for it, you have to get it. So you might as well be prepared with what it is they're likely to ask for. To say to a buyer who asks for reasonable materials and say, it'll take me 3 weeks to get that to you, kind of raises a question. How well organized is your company? It's far better to get that done before going to market. It could be done 2 years in advance. It could be done in the 6 weeks prior to, but it should absolutely be done in terms of doing due diligence on yourself. The second time that due diligence should be done is basically when you're in what I refer to as the dating phase. You're out in the market and buyers are coming and taking a look at your company and saying, oh, I like this. I'd like to put in a letter of intent. At sbLiftoff, we say no. You can't put in a letter of intent until you've done decent due diligence. We need to know that you understand the strengths and the challenges of this company because we want that LOI to be worth something. And for you to say, oh, well, just put in a price and we'll do the due diligence afterwards, that's asking for a price adjustment. That's basically saying, oh, the buyer didn't know what they were doing when they put in the LOI, so we can reduce it by 20%. No, that buyer, if they're not willing to put in at least some serious effort on due diligence, they're not somebody worth getting an LOI from. And then after the LOI, there is extensive due diligence. But hopefully, that due diligence would be confirmatory in nature. I've never yet seen a deal that didn't go because of the insurance or the benefits and all sorts of things that the buyer has to do a deep dive into. But that's not the kind of reason that deals die. They die because there was a serious accounting issue or there was something that was not disclosed. All of those should be disclosed prior to the LOI, so it's kind of confirmatory post LOI. Marlena, do you have any thoughts about that?
Yeah, no, I think that's right. And again, I think, I hate to, I think lawyers have the perfect, right? We have the perfect. And what our wish list would look like. I don't want to discourage anybody from this process thinking, oh, I'm just so behind the curve. I think get started right. And right size it for your company. Of course, if it hasn't been clear, which hopefully it has, there are going to be issues with companies and there is going to be negotiation and, it can be a painful process. Hopefully your advisors make it slightly less painful for you. But I think, just be prepared, I guess, as much as you can, but don't let that, get in the way of you getting started or you looking at this process. Because I think, it can all be done and, there's disclosure schedules when there are issues that maybe will continue post-closing or something, that you work through. I think the earlier on, to your point, Sharon, that you can identify those issues, the better, because your advisors can help frame that, right? And there's no surprises later, which might lead to a price reduction or some material term of the deal that doesn't make it worth it for you to move forward. And now you've spent fees and you feel a little bit of pressure and you don't want to start all over again. I think putting in some work up front will pay off in the end.
Talk about that a little bit, and Brad, I'm going to kick it to you,
Yeah.
which is what you were really just talking about, Marlena, is value.
Yeah.
What is the appropriate value for your company? If there's appropriate due diligence done before you go to market, the market should, we're to live in a capital, your company is worth what a buyer is willing to pay for it. But if you're told that your company is worth, I don't know, $20 million and you wouldn't sell for less than 30, well, maybe it's not the time to bring your company to market. If you think that you're going to be able to sell your company for 20, but you're kind of hiding the fact that you've got recompetes coming up that represent 30 or 40% of your revenue and that's coming up in the next 18 months, you're not going to get to closing on that. And that 20 million is going to come down. So it's really important to pull this information together so that you can get a realistic sense as to the value of your company and make a decision as to whether or not that's something you want to go to market with. It is I occasionally see sellers waiting for the strike of lightning. Oh, yes, I understand that my company's worth 20, but maybe somebody will pay me 35 for it. So I'll just keep it on the market for a really long time until I find that particular buyer. Well, it's not necessarily a good idea for a lot of reasons. Brad, do you have any experience with that?
Yeah, and there are a couple of great points that I've been biting my tongue to not just talk over everybody, but which I have a tendency to do. But one of the things, and you talked about the LOI, and I would say, and I don't have evidence to back this up, that if there are let's say there's 7 significant, I mean, not deal killer problems, but problems with there's some hair on this deal, right? I think you are better off having disclosed all 7 of them up front than you are the buyer only finding 3 of them, right, on their own, because as part of their due diligence. Because even though they may only know 3/7 of the problem, you're still worse off, because now you've either been hiding stuff or you don't know what's going on, and your trust is gone. And this gets back into this sort of LOI situation, where yes, LOIs in general are non-binding, and there's actually for the GovCon, there's even more reason to make them non-binding, to avoid getting into affiliation problems. And we can talk a bit more about that, later. But it's, and it's always like, yes, and it's subject to this confirmatory due diligence. But you get back to this sort of, and if you haven't seen Casablanca, just go see it and then come back and watch the rest of this. But it's like, it's that point where it's like, I'm shocked to hear there's gambling in this establishment, right? It's like, if you sign an LOI knowing that there are these 5 problems, and you agree on, it's like, yeah, this is a $30 million deal, and it's like, and all of a sudden they find these 5 problems, it's like, well, that is, I mean, if they're going to try to negotiate down based on that, it's like, well, it's all non-binding. It's like, but you knew about that, right? That was built into this price. So the fact that you're doing that, you're not arguing in good faith. And does that mean you're going to win? No, but they basically have to be negotiating in bad faith to do that. And quite frankly, the other part of this is comes down to leverage, right? And even if you are a $20 million company negotiating with $1 billion company, now you may be too small to negotiate, but whatever that situation is, you do have some leverage. And the most leverage you have is before you've signed anything, usually, right? It's like, if you can walk away, that is your leverage, right? And if you have 2 companies that are interested in buying you inherently have more leverage. You have the ability to raise that price, because if, someone could do any number of analysis and say, you're a $25 million company, but if this other guy's going to pay 30, then you're worth 30, right? So, and before you have gone exclusive in this LOI, and that's about the only part of an LOI that generally is binding, that and confidentiality and some other like legal nonsense. But basically it's hey, we're going to go exclusive for a while. So now you're losing leverage, right? And now you've lost that other potential buyer, perhaps forever. I mean, they may be a backup, but having someone on the side is not necessarily that's not your strong suit, right? So when you're still open and you can say, here's some problems, but you still love us because we have these great, we have a great relationship with this government customer that you're interested in, or we have this fantastic technology that would be perfect with you. And we had a little problem here, and maybe there's some issues over there, and but having that up front at that, at the LOI, as you say, they've done that diligence, and most of that diligence is going to be financial, quite frankly, right? It's like most of that pre-LOI diligence is looking at the customers and looking at the financial statements and stuff like that. They're not looking at the board minutes and things, but knowing what these issues are, knowing where there's some gray areas, knowing where it's like, maybe we had some EBITDA problems, or maybe we have some, there's some holes in some of our, whatever that might be. up front. And if they're still signing that LOI over that, then it's like, well, you knew about that. Okay. So now this is now the baseline. We're not moving off this because you knew there was gambling at risks, right? So don't pretend that you're like, now we need a price adjustment based on that.
Well, let me tell a story exactly on that point. We were working with a GovCon company that was producing product for the government and had a billing cycle where they got 25% of their payment at each of these 4 milestones. Well, it turns out that the first 2 milestones really didn't take a lot of effort. And the 3rd milestone took a huge amount of effort. And the 4th milestone was pretty much normal. We disclosed this to the buyer. We basically said, we are not following GAAP revenue recognition requirements. Here's how we're doing it. And, just full disclosure. We went to an LOI and the buyer then did their quality of earnings report and came back and said, oh my gosh, you're not following GAAP. We've got revenue recognition problems. We're going to have to do a price adjustment of X, Y, and Z. And we said, no. Hey, listen, you don't want to do the deal, don't do the deal. But this is exactly what we told you prior to you signing the LOI. We're not going to do a price adjustment for something that you knew about. If, on the other hand, we hadn't told them about it, we would be in the wrong.
Yep.
So we were actually protecting our client. That deal went forward at the price of the LOI. One of the things about a price adjustment is that that's not necessarily the worst case scenario. The worst case scenario is that the buyer looks at the seller and says, you didn't know about this problem? Well, maybe you don't have control of your company. What else is happening that you don't know about? Or you did know about the problem. You didn't tell me. I don't trust you anymore. I don't feel like I can go forward. So in some ways, a price adjustment is bad, but it is better than simply pulling the plug. Marlena, you must have seen examples of things like this.
Yeah, and just to kind of add to that, we have stories where, if it's hidden, let's say the deal does close, and then the buyer starts running the company, guess what? That issue comes up. I mean, obviously we wouldn't advise them to hide it, but let's say an issue comes up post-closing. We've had in our litigation department, right? Companies come and say, hey, by the way, that earnout, right, or that escrow amount no longer on the table, and guess what? They have the money and you don't. So, come sue us for it. Also, indemnification obligations, especially for the reps and warranties. That was kind of part of my point for the due diligence, knowing what your contracts say, what your requirements are, making that rep in the purchase agreement. An indemnification provision, lawyers love to fight over those provisions. And I think clients usually don't fully appreciate, right, the implications of them. But, you personally, in some instances, depending on how the deal is structured, may have to indemnify the buyer for issues that occur post-closing that you didn't disclose on a disclosure schedule, for example. And so, the mountain can continue to grow. So it's not just the deal doesn't close, but it can actually come back to you, which we've seen post-closing as well.
We talked a little bit about valuation, but I want to talk about some issues that are a little bit unique in GovCon. One of the things we said was, we're going to talk about customer concentration, contract concentration, et cetera. And if you talk to PE, those are kind of critical components for them. We want to avoid concentration. No client should represent more than 20% of, et cetera, et cetera, et cetera. Well, in GovCon, there's absolutely client concentration. There's one federal government, and that government is where that federal contractor is getting all their money from. So you have to look at it differently. And people who are in GovCon understand that. So it's not so much customer concentration, it is contract concentration. You could have a company that's incredibly strong, but gets all of their work from, let's say, the VA. Now, do they have one contract that represents 80% of their revenue? Or do they have 15 contracts with different departments within that the VA? If it's all coming out of one office, then there's probably one decision maker and maybe there's more risk. If in fact you're getting it from a lot of different offices within the VA, less concerning. On the other hand, if the seller is an SDVOSB and all of their work is coming from the VA, well, the buyer had darn well better be an SDVOSB that could really step into those shoes, because the VA is not really great about taking SDVOSB work and giving it to non-veterans. So you really need to be looking at a lot of those kinds of issues in determining the value of the company. Brad, you must have a lot of experience with this.
Yeah, and yeah, as you say, it's somewhat sort of counterintuitive and kind of the opposite of, in general, private equity and other commercial buyers are often very much what they don't want too much concentration, because you lose one customer and then that could jeopardize the entire company. But depending on who the buyer is in the government space, sometimes it's quite frankly not even necessarily the contract itself, but it's it is those relationships you've built with particular government customer that perhaps is the entree that they can sort of cross market some of their other technologies or their other services, right? So being in the right place, that alone could be worth a lot to a potential buyer, depending, right? Just because there is a finite number, even though there's tons and tons of different places you can be doing business with the government. There's definitely a finite number of places that, especially depending on what you're selling. If you're selling custodial services, then presumably everyone's got a building needs it. But if you're selling a particular missile technology, stuff like that, Department of Agriculture is probably not particularly. I mean, I don't know, maybe they are.
We hope.
I mean, I don't know. For all I know, I mean, I guess they could be militarizing, but all joking aside, that it's like knowing what is interesting for a potential buyer. Once it gets back to preparation, and one of the things that we often see is, as these companies are growing, especially when they're like, they'll grab whatever they can in terms of a contract. So yeah, I can do that, because why not? I can make money. All I have to do is hire some people, and I'm making money off this contract, right? So so I have some services, I'm selling some product, I'm doing different kinds of services, which can be totally great. And some of the big boys obviously do that. The issue becomes, well, what is that worth as a whole to a potential buyer? Because they may not be interested, they may only be interested in one part of what it is. And the more divergent those lines that you're in is, you're doing custodial services, but you're also doing like IT integration, and you're doing cybersecurity. And it's like, well, I'm not really sure, what am I going to do with some of this stuff? Because I'm not just interested in having your revenues. I'm interested in the kind of revenues you have and the kind of customer relationships you have and how that will help grow my business if I'm looking to buy you. So as part of that process of like, well, what contracts do I have? What are interesting to a buyer, which are going to be problematic if they lose because I am in one of these SDVOSB or one of these other programs, and either they aren't going to be, you're not going to be able to renew them or rebid them, or whatever that might be. Are those going away? So it really, it's like, what value do I get for that? Or or is it still useful to the buyer, right? So knowing who the potential buyers are, knowing what that all looks like, goes into that valuation determination. And so you have to be cognizant of it, right? So you've got to be.
It's actually an excellent point. We have spoken to many people, a lot of veterans, who say, my company's an SDVOSB, I can't sell it. And the answer is, yes, you can. You absolutely can. You can sell a company that is small business, or an SDVOSB, or a woman-owned, minority-owned. 8A is a special issue, and I'm going to turn that over to Marlena as for the difficulties of an 8A.
Yeah, because I don't
know. But this situation is different for companies that have these set-asides than for companies that are in the full and open market. Truth is, it's very rare to find a company that's under $20 million in revenue that doesn't have some level of set-asides.
Mm-hmm.
But those companies are absolutely sellable. There is a bit of a life cycle, which is, if you are pretty far away from your 5-year revenue code to sizing out, then there's a pretty active market. If in fact you've already started poking into the full and open market, and you've got 20 or 30 or 40% of your revenues from there, you're going to get a better valuation. If, however, you are in the designation market, the size out is clearly on the horizon, a year, 2, 3 years away, and you've not done anything to get into full and open, your company is still sellable. but it's going to be a lower multiple because there's absolute risk associated with trying to break out of the set aside world into the full and open. And either you, as the business owner, can do that, or if you decide that essentially you're going to run a lifestyle business until you get to that revenue cap and then you're going to transfer that over, you've got to recognize that there's going to be a discount put on your company because the buyer will be taking that risk to go into the full and open market. Marlena, do you disagree with anything I said? And certainly then please talk about 8As.
Yeah, no, I think that's right. I think, you know, you can be in either category, right? You can be in the category, I would maybe categorize it into two for simplicity. But I think you can be in the category where your buyer, you know, you're looking at is somebody that can continue to be in the set aside category as an SDVOSB or women-owned small business or the 8A program as well. You know, or you can be in the category where, you know, you don't want it to necessarily be limited to one of those individuals that can continue that set aside status, right? And you want to go out and blow your size status, you know, but you need to recognize that early on, which category you want to be in and which category you actually are in, I think before you go to market, right? So decide, am I looking for a buyer that can continue to win set aside work, or am I looking for a buyer who, you know, we're out on the open market, we have enough in our pipeline, we have enough, you know, full and open contracts that aren't necessarily dependent on our set aside status, that we can market ourselves to other buyers and not the categories, you know, the set aside category that we currently qualify for.
Ali, let me interrupt you for a second and put some numbers to that. If you are in the set aside market, your multiple of EBITDA for purchase price terminations is going to be somewhere between 3 on the low side to maybe you can get to 5, 6 with some structuring. For an extraordinary company, you might be able to do a little bit higher. If you're in the full and open market, however, you're going to be starting at like a 5 and you could go up to a 9 or a 10 or 11. So the same $3 or $4 million of EBITDA could be worth $4 million of EBITDA could be worth 8 million, or it could be worth 40 million. It makes a huge difference, that full and open. But it's challenging to get into full and open. So you need to decide what kind of company we're talking about here. If you have a designation company and you're selling it as a designation company, that's fine. There is an absolute market available for that. If, however, you're looking to get a higher purchase price for it, then you need to start poking into the full and open. But there's risk and expense associated with that, as well as time of your life. And you may or may not want to do that. And either decision is fine. But don't think that you're going to be in the designation market and then sell for a multiple that a full and open company would. I apologize for interrupting.
Yeah, and a lot of that really comes down to the buyers aren't buying your past, except you know, maybe your past performance, but that's a whole nother thing. But you know, they're not buying your revenues from last year, right? They may be using that, but they're using that as to try to project what they can do with a company that can execute like this when they're owning, right? With their, whether it's a different, you know, marketing team or a different management team or whatever that might be. So to the extent that even if, you know, arguably even if like 90% are set aside contracts, but you have shown that you can compete, that there are people, there are buyers, there are interested in what you have to offer in an open market. I think that shows in every industry, showing that product market fit, right? How our customers, are they sticky? Are they coming back for more? You know, that's what even the newest startup companies may get massive valuations because they've shown that people are interested. They may not have millions of customers, but the customers they do have are very interested and are willing to buy it, and so they can show how they can grow that, right? So I think it's the same kind of principle here. If you've used those programs to help you grow that company, so you can get to the point that you now have a technology, a service, a something that is expandable with the right resources behind it. You may not be able to do it yourself, but somebody else can come along and take that and go, yep, now we can flip a switch. We can throw a bunch more money at this and grow it to that next level as part in our suite of businesses. I mean, I think that's all the difference. That's how you can get more up to that, so that all of a sudden that $3 million in EBITDA, it's not the same depending on what it is, but you arguably you have a good argument. It's like, yeah, we did this. Most of this may still be, in these set aside contracts, but now we're in this, but we can compete, and we're starting to compete, and we're, and the customers are still there, are happy with us, not just because they can check a box, but they're just happy with our performance because it is, it is what it is. And I think this gets back to that. Anything you can do to make it easier for a buyer to get to yes is good, right? They don't, if they're trying to convince, whether it's their partners or, the head of corp dev or the CEO of the company, whoever that might be, that yes, this is the right kind of company for us. Look what they have done in the past. This is the kind of company that we have success with buying, right? So the more you can do that, even if it's just a hint at it, even if it's just a suggestion, even if it's a small part, I mean, I think it shows the ability to grow so that they don't have to guess, that they're like, well, yeah, I know they've never tried to, they've always been in the little cove there with no headwinds, but I'm pretty sure they'll be fine. But any hint that you can, any confirmation that you can get on that, I think is a good part of the story.
That's a very good point. I just want to say we're in the last 10 minutes of this, so I'd encourage anybody in the audience to put in questions if you have any. Marlena, I'd like to turn back to you to talk about the difference between an 8A acquisition versus, let's say, an SDVOSB or simply a small business. Most of these deals are done as stock deals for purposes of being able to transfer those contracts over. And you don't have to go ask the government, Mother May I, to do that. How is an 8A different, Marlena?
Yeah, so I mean, I'll just start off by saying all of those, right? Any of the set aside categories, you are potentially going to run into potential risks, and I'll give you one example. Sometimes, an SDVOSB, for example, will say, "Hey, I'm an SDVOSB. I've been in this space. I want to acquire another one," and not realize that, okay, well, now that we've acquired this other business, we're no longer small. So I will say that just in general, same thing for 8A, same thing for women-owned small business. So you are going to have some of the same affiliation issues. The 8A program, so typically, when you, let's say you do size out, for example, for an SDVOSB or woman-owned small business, generally speaking, now there's some exceptions, that's why I say generally speaking, the contracting officer will allow you to continue to run out that contract, right? And so, yes, this was a set aside and we're no longer an SDVOSB, but the agency won't get credit for awarding it, but they'll go ahead and typically, because so long as your past performance is good and they're not looking for a reason to terminate you for convenience, they generally will allow you to continue to run that out. There are some exceptions for, scheduled contracts. If they're exclusive for small, there's sometimes provisions in there that will not allow you to continue to run out the clock there. But the 8A, there is not that kind of understanding where, okay, well, you're no longer an 8A, but we'll go ahead and allow you to continue and run out your contract. You actually have to get a waiver from SBA, and there's only, a handful of exceptions that SBA will allow you to continue to run the contract. One of the most often being that you're being acquired by another 8A. And so I think that is probably the biggest difference to keep in mind if you are looking at an 8A, making sure that those contracts aren't going to go away the day you close. I mean, not literally, right? It takes the government a little bit of processing time, but that your pipeline is actually going to continue post-closing, that you meet one of those waiver requirements, versus when you're, acquiring an SDVOSB or a woman-owned small business. Generally speaking, they'll allow you to continue with those contracts post-closing, even if you size out.
Very interesting. Before we close, I very quickly want to talk about what is the process. We talked a lot about being prepared before you go to market. I've seen people say that there's a 20-step process, there's an 8-step process. sbLiftoff, we like to keep it a little on the simple side. We say that there's 3 stages to this process. One is all the prep work that you do before going to market. And that could go on for a month, it could go on for 2 years. But that's when you're gathering all your documents and kind of understanding your valuation and figuring out the strengths and challenges of your company. And it's kind of an internal facing process. When you're working with an M&A advisor, that's also when we're not only determining the value, but figuring out who would be a likely buyer and putting together the lists of who we're going to reach out to, as well as the marketing materials. And the marketing materials generally have a teaser, which is kind of statements about your company, but blind. People should not be able to read that teaser and say, oh, that's Joe's company. So there's the teaser. And then second is the confidential information memorandum, which back in the day used to be an 85-page memo that was incredibly detailed. Now it's more likely to be a 12-page PowerPoint slide because there's lots of information that could be given. But the idea is to give out the information in pieces. Our feeling is get to a fast no. Don't reveal everything about your company to anybody who asks. If somebody's the wrong buyer, let's find out early, get them off, and they haven't actually gotten to a huge amount of your information. So it's very important that you break that information up into tranches. Phase one ends when you start talking to other parties, when you're trying to reach out to buyers. And we refer to that as the dating phase. That is when, hey, listen, you might find love at first sight on your first date, and that's fantastic, but you might have to kiss a couple of frogs before you get there. So, that phase, you're not quite sure how long it's going to take to find the right party. And it ends with the signing of the letter of intent. Phase three is letter of intent to closing. Brad, would you talk a little bit about the importance of signing that letter of intent? You've already mentioned the idea of exclusivity and the power negotiations changing between the parties, but why is that LOI so important?
Absolutely. And it is really important. And there too often I hear people say, oh, but it's non-binding, so it doesn't really matter. So just whatever. And sometimes people want to have a very basic generic LOI just to build momentum towards closing, which I mean can be useful because it's like, well, now we made it to that next step. The problem is, and because it's non-binding, it doesn't necessarily matter that much because all you're agreeing to is a sort of an exclusivity. But what I like to push for having as much of the key business terms in that LOI very much for the reasons we talked about before, that it's like, listen, let's just, if this is going to be, purely a price based on, an EBITDA multiple, then fine. But if if the price is based more on, this feels like a $20 million company because that's the kind of, because I think, with the contracts or whatever it is, it's a $20 million company, not because that is 3.7 times EBITDA, right? Because then I don't want people making those adjustments later based on, well, no, actually the EBITDA is lower. It's like, no, it's still a $10 million company because it's still, everything's the same, except, maybe we didn't do, maybe we shouldn't have been counting some of these family payouts or whatever it might be, right? So it's getting the business terms, what it is you're promising, what it is, the kind of stuff, maybe you had a whole bunch of like spare parts and stuff like that is on your LOI, and it's part of your business. It's like, is that a key part of the value, or is that just stuff there, right? Because I don't want adjustments based on, it's like, well, you said that was like $1 million worth of spare parts, but it's really only $750,000 worth of spare parts based on our valuation, so we're going to reduce the price. It's like spare parts are just stuff that we had, right? So figuring out what those, what it is that we're promising, what it is, what are the key items in there that we're basing this on. And then things like, is there going to be some kind of non-compete provision? Is that 2 years or 5 years? What do you need? What is it? Are there going to be key employees that have to stick around? Because that changes leverage for some of those people. So there's a bunch of things that, you want, the more you can lead with those, especially if you're on the selling side, it's like, because you don't want to give that wiggle room, right? So having as much as possible in that LOI about, where that's like, no, we're agreeing on this and we're still signing and we're going to move forward, even though it's not binding. I think that builds that, that momentum towards doing those deal documents. And obviously, an LOI could be 2 pages or 5 pages or 7 to 10 pages, and your purchase agreement could easily be 100 pages plus other documents, right? So obviously not everything's going to be in it. But too often I'll see things like, well, but it'll be subject to standard adjustments. It's like, standard adjustment, that's not really a thing. That's in the eye of the beholder, right? And it's like, I think standard is this, and you thought standard was that, right? So if there are things that are important to you, the more you can get those in, because it's a lot easier for people to say, yes, that's fair and reasonable when there's leverage, when there's, as opposed to, well, no, there's something different here, so we're going to do dollar for dollar, that's what we agreed to. So the more businessy the terms that you can get in that LOI, in my opinion, the better, because it's less vague, it's less room for, and quite frankly, even if some people are trying to gotcha, there's less room for people to have a misunderstanding. It's like, no, we have that, there's a concept in contracts of meeting of the minds, right? And it's like, the more that we agree that we're talking about the same things, the better. And on those key issues, I generally think that's a good thing rather than trying to hide the ball.
I think it's time for us to turn this back to Jennifer. We want to respect the time of our audience.
Well, I want to thank you all. Thank our speakers, Sharon Heaton, Marlena Ewald, and Brad McConnell for an informative discussion. And all who have attended, thank you for joining us today. If you have any questions, please don't hesitate to reach out. The emails are on the slide that you're seeing right now. So please reach out if you have any additional questions, and we hope you all have a wonderful day.